Okay. Let me go back to this section here. I'm super delicate. I don't know why it's so delicate today. Okay. All right. Again, just checking in. People on Zoom, can you hear me okay?
Yes.
Okay, awesome. And also, do you see the presentation on your screen? The BRBC?
Yes.
Yes.
You can.
Okay, fantastic, awesome. All right, well, let's go ahead and get started. So today's session is going to be the Buyer Representation Agreement, better known as the BRBC. The reason I wanted to have this conversation is because I've been having a lot of questions around this. One of the questions is it mandatory to have the BRBC as part of our process when we submit an offer? Okay, I think all of us by now should know that the answer is yes.
Yeah.
Yes, this is part of your initial process now, that you must have this as part of your process to get your offer submitted. You know, this was a national calling that transpired last year in 2024 around August, when there was all these big changes. Now, the buyer representation agreement has always been part of our practice, but now it was enforced that in order for you to be paid compensation, we need to have a written agreement between the buyer and the seller. This is the reason we have these documents signed and executed by the buyer for that sake, to protect you, but also to protect the buyer, and also understand what is the element of your position as a real estate agent and the position of the buyer, right? Because again, looking at the bigger picture, I hate to say this, but buyers sometimes are not loyal. And these are the reasons that these agreements were added to our zip forms for that purpose, is so that way the buyer knows their duties and responsibilities, and also as a real estate agent, our duties and responsibility when it comes to how to navigate it. Now, we're going to dive into the conversation on the BRBC. It's a pretty self-explanatory, and I get this quite often, and I want to put this to rest, is that I get the agent saying, well, this is an overwhelming agreement that buyers just don't feel comfortable signing. And I have to disagree, okay? Because if you know how to present it in a way that reinsures the buyer's position, it's no difference than going on a listing appointment, folks. And what I mean by that is this: you wouldn't go and sign a seller without proper documentation. One, you would be entitled to compensation. What the buyer representation agreement just stipulates is that says to the buyer, hey, I'm going to work for you. These are the things that I'm going to do to get you to what you need, right? Find and identify, negotiate, open, go through the motions of inspections, navigate the conversations with the opposing agent, talk to the lender to make sure that the loan is going where it needs to go, and making sure that this process gets us to the finish line, right? And the finish line is where we get our ultimate reward, right? Which is being paid for services rendered. So in essence, the big takeaway here is, if you don't have a buyer representation agreement, it's like, okay, you're not going to get any compensation. This is why you want to sit down and consult and really have the conversation with the seller to understand how all this works. And once you show that value, then they'll be more at ease in understanding and how they sign this. Because the first thing they say, I'm responsible to pay you commission. You're saying, Simon, I have to pay you compensation for finding and identifying the property? The answer is yeah. And you have to be comfortable with that. This is where you build a skill set, but once you know the ins and outs of this agreement, then it makes it a lot easier for them to sign the document and move forward. Okay? And I'm going to show you a simple way in how you navigate the conversation. Right? Part of the process is once you have someone that is interested in buying, it's like anything else. You're going to tell them throughout the initial process, there's going to be a lot of paperwork that we're going to sign. You're going to be like a celebrity. You're going to sign an initial and date, and it's going to be multiple paperwork that you've got to do in order to get to the finish line. So I want to prepare you now that that's going to be part of the process. You're a rock star. You're a celebrity. We're going to have to sign documentation. Part of it is my duties and responsibility as a real estate professional to you. My obligations is to help you identify and go through the process of ultimately closing the deal. And part of my responsibility is what we call the buyer representation. It's a representation between you and I and me to you, saying this is exactly what we're going to do. And it's a non-exclusive or an exclusive agreement. Okay, meaning you can work with me exclusively or you can work with me non-exclusive. But the purpose and the position that I want to, for both of us to understand is I want to be able to navigate this as an exclusive, finding and identifying the right property for you. Does that make sense, Mr. and Mrs. Buyer? Right? So part of it is the preparation of the agreement. Okay, that's obviously the right to represent. Just like going to an attorney, right? I need to know who I'm going to be representing and working with. So part of it is your information. The next, it gives me the grant and the responsibility to now help with the next step of finding that perfect home. We as a company, which is Keller Williams, right? Keller Williams South Bay is the broker who's going to represent. Now, the non-exclusive right, exclusive, it needs to be checked off on paragraph 2A2 and initial in paragraph 15 to represent buyer and inquire in real estate property or manufactured homes. So this is just, again, part of the initial process for me to get to work. Because right now, I'm unemployed. But the minute that you sign this, now that puts me to work. Does that make sense, Mr. and Mrs. Buyer? Okay. Then we go into the terms of the agreement. Okay. The terms of the agreement is the representation part. This is what we call the grid. This is the grid. And part of the grid is all of the information that says, what are my duties? What are your duties? And so on and so forth. A1 goes into the period, right? The period that I'm going to be working with you. Now, I also want to put this as a disclaimer because it says not to exceed 3 months unless the buyer is a corporation. So if it's just a traditional consumer, then the maximum amount that the buyer representation agreement shall be is 90 days, 3 months. If it's a corporation, an investor, LLC, S Corp, C Corp, then we can extend it beyond that point. So know the distinguishes and know the difference. Okay.
Simon,
Yes, sir.
I just want to mention here that thank you, and I want to thank my mentor Leslie because you guys discovered. Remember, I was up against an agent with 30 years experience.
Yes.
And they put 4 months instead of 3 months, and it's because of you guys and your knowledge about the contracts. I was able to make my client work with me because the contract that she signed with that agent was void by nature. So
That's
I just
right.
want to, I understand when you said we have to know the contracts as agents. So thank you for that.
Absolutely. Thank you. I didn't pay him to say that, by the way, but thank you. Yeah, it's so important, folks. It is vital, important for you to know these contracts because those are the loopholes. That's where you can work with other consumers because they may not be happy with the agent they're currently working with. They may not even know that that buyer representation agreement expired already or void because it says that this cannot exceed 3 months. And it says buyer, it says period exceeding 3 months, buyer is not an entity this agreement is void. So then that's the conversation you can have with the consumer is if they have 4 months, 6 months, and it's because a lot of agents are not reading these agreements. They think it's still the old school way of doing it. That's your exit. And that allows you now to work with someone because you found that loophole. So you look like a superhero because they may not be happy and they feel like they're tied with this particular company. Here's your answer to your question. Now, 2AB, B4 talks about what type of representation is this, folks, okay? Now, this is automatically a non-exclusive agreement. We have to check it as an exclusive agreement. By doing so, you check it, now it becomes an exclusive. Valid only if checked. If you don't check it or you miss it, now this form is considered a non-exclusive. You need to check it to be an exclusive agreement. And there's benefits to having an exclusive towards a non-exclusive agreement, okay? Now we go into the section of the type of property that we're going to be looking. So you want to make sure that you're covering all angles on this, right? So the type of property, single family residence, it's already defaulted, okay? Meaning that you don't have to check anything if that's what they're looking for. And that's again going back to the conversation. Conversation when you sit down with the consumer is, what type of property are we going to be looking for? Are you looking for a house? Are you looking for a duplex? Are you looking for a triplex, fourplex? Are you looking for a manufactured home? Are you looking for a townhome? Are you looking for a condominium, right? You got to be specific. You got to ask those questions so that way you understand where you stand. Now, it also has different boxes to check. If it's not an SFR, is excluded from this agreement, then you would check it, including condominiums and manufactured homes. Multifamily, you're going to check if it's a multifamily residence for 2 to 4 units. With more than 4 units, then you would check with 5 or more units. It's industrial, vacant land, commercial, tenancy in common, the following specified properties, then you would pick and choose the specifics. B2 goes into location. And this is where I need to warn you, because I've seen mistakes happen in this section. You got to be very specific. It does have 2 sections. It has county and it also has cities. Okay. So if you say just city and you say the city of Long Beach as an example, okay, and you put the city of Long Beach, right? Then the buyer goes into an open house outside of the scope of Long Beach, and let's say that they now go to Los Angeles, right? They go into an open house, an agent is hosting an open house, and they influence that individual to write up an offer because they fell in love with the property, right? And now you find out that this buyer went with another agent. Okay. Now, a lot has to do with the section up top, right? Exclusive or non-exclusive too, right? And we'll go into a little bit more on that. But if you only put the city and this individual consumer or buyer doesn't buy that particular area, then unfortunately they're not obligated to pay you compensation. That is their loophole. Okay. They can argue the fact that I can state the fact, Simon, I gave you the opportunity, but the opportunity was only in the city of Long Beach. Anything outside of the city of Long Beach is void because we were not specific about that. Anything within Long Beach, I'm more than happy to pay you compensation. Anything outside of Long Beach, unfortunately, I don't think I'm obligated to pay you compensation. So how do you protect yourself in those situations? Well, one, be crystal clear. I am licensed in the state of California. My goal is to find any property in any desirable area, right? To identify, negotiate, and ultimately close the deal. So in order for you to protect that umbrella, broaden that specification of location. I would put County of Los Angeles, because Los Angeles has multiple cities, right? A lot of cities. So if they end up buying somewhere outside of Long Beach, you're covered. Okay, we can now go after compensation. So be very specific. I'd rather put counties. I've even seen agents put 4 counties. Los Angeles, Orange County, Riverside, San Bernardino, right? Hey, you're covering all bases. With those 4 counties, that's, over 60, 80 different cities or more, right? And if these buyers end up buying in any of these counties or any of these cities, well, we can still go after compensation. Make sense?
Simon, question.
Yes.
But that's only if you show them those properties, right?
No.
As long as you just put
Yeah.
it in there, like the counties.
It depends. If you have an exclusive agreement, then even if you didn't show them the property and they go out to Riverside and buy a house in Riverside, you're still entitled to compensation, even though you didn't show them.
Right.
Okay, because you covered all bases. Because most time the consumer will find their property on social media, right? They'll go into Zillow. Maybe you give them your app or your MLS access, and then they start researching. Hi, I want to see this, and one, right? And maybe they're hosting an open house out there. Now, this is where you also want to educate the client, right? And I always think of it as egos and vultures. Egos and vultures. Why I say that? Because my instructor, even before I got my real estate license, he was this guy was probably 6'5", 6'8", big man, tall, huge. He looked like a football player. He was probably in that time, maybe in his 60s, maybe even late 60s. He was my professor at college. But he was an owner of a real estate company out in Hacienda Heights. But he was a professor at the college, and he would tell us war stories. We didn't talk about anything because his curriculum was real estate practice. That was his class, and he would just share war stories. One of the most influential individuals that I ever met. He passed away many years ago, but I still remember the philosophy that he would use. And think about a 6'5" guy, big football player, awesome guy, and he had this big and distinguished voice that surrounded command presence. And I'm out here as a college kid thinking, man, gosh, never want to get into an altercation with this guy because he was a big man. But he understood because he had already done 30, 40 years of experience. I mean, he was from the 60s, 70s, and 80s and into the 90s, running a very successful real estate company. And I remember in front of class, he would do this. And he says, the egos do this. The vultures do this. And what he meant was agents. Okay? You got egos and you got vultures. Okay, and what do vultures do? What do? They usually wait until the prey is dead, and then they go and start eating the carcass, right? Or eagles are out there looking for live prey, right? That's what he said about distinguishing. There's a lot of agents out there that just do not practice good moral practice in their business. They're vultures out there. And they'll do whatever it takes to take advantage of your clients. I hate to say it, but it's true even almost 30 years later that there's still agents that just do not practice good practice. So it puts a lot of mind and sense to me of how you have to protect yourself from the vultures, okay? Because there's thousands of agents out there, but not all of them are following the same rules and regulations. This is why agents ultimately get slapped. This is why they get their license revoked, because they're doing things they shouldn't be doing. But the way you educate and protect yourself and your client is by sitting with them and explaining the pros and cons and why they need to sign this. It's a shield of protection at the end of the day. I want to protect you from all of these individual agents that are going to tell you when you go in an open house that you should be working with me, right? This is why we have an agreement in the first place. So you understand and I understand what our roles and responsibility is at the end of the day, folks. That's how you explain it to them and how you get them to sign these agreements. Okay, so you want to be very specific. Additional description is there if it's very specific. Okay, if it's a very specific what they're looking for, then you want to just add that additional, right? Maybe they're looking for a property that has livestock, right? They want like a farm with animals, right? I'm just thinking out loud, right? Well, you want to protect yourself because if you find something in the Los Angeles County or the Riverside or San Bernardino, and they're looking for like a farm that they're also willing to, provide with livestock, there's properties out there. And you don't put that as a specific, they can argue the fact that we were looking for a property that was very specific. And therefore, I believe that this particular property doesn't hit the parameter of this agreement. And therefore, I don't think I'm responsible to pay your commission. Now, it's all, again, based on evidence, right? It's their story against our story, and then we present it and ultimately let the mediators handle who is right and who is wrong, right? But the more information you add, you have to be that investigator, right? Be very detail oriented and document everything that you know about what your intentions are and how you're going to protect that position from compensation. Because at the end of the day, folks, your buyers are responsible to pay you commission. Yes, you commission. Now, I'll explain the language that does say that if anyone else credits the buyer's obligation, then that offsets them to pay you commission, right? And that's where we get into the purchase agreement and G3 and submitting a request to have the seller pay us commission. Any questions so far? We're on the same page? Good. All right, additional buyer preference and priorities. If you check that under section C, then it populates the form BIPP. It is not required, but if it's very detailed type of request from the buyers, then I would check that box and then that populates the additional buyer preference. And it goes into if they want a pool, if they want a certain square footage and lot size, if it has a basement. I mean, it's really detailed. Then you would add this additional advisory or supplement to the buyer representation agreement. D goes into properties excluded from representation. All right, so let's say that this buyer had been working with multiple agents in the past, okay? And to protect themselves from paying multiple compensations, because they may be responsible to pay because they've been working with other agents as well, right? And maybe they had an agreement that's still, right? It's still valid. Because again, they can work as many different agents, but also know that they may be responsible to pay all these agents compensations if they go after them. So this is why we don't recommend a buyer to sign just to sign, because each of those individual agents can come back and say, here's my bill for compensation. Okay, you breached the contract, so I'm entitled to my commission, and that can happen. So this is why you want to be clear on those, and the buyer needs to understand, hey, I don't want to be obligated to pay double or triple commissions, therefore I'm excluding these particular properties from this. Because if I go back and buy this property, I'm not responsible to pay you, because I might have a deal with another agent, and that can happen. These are your investors. Okay, so investors are constantly hunting for business, right? So they may have multiple relationships with multiple real estate agents, They're not just gonna be tied to you because you may not have that property, but another agent says, hey, John, I have this property. It's a fixer. It needs a lot of work. It's a great property in a great location. It has good potential to make a decent profit. Are you interested? One investor is going to say, no, I'm already working with Simon. No, bring it. Because their number one goal is to try, right? Try to make deals, structure deals, renovate the property, and then turn around and put it on the market, right? That's their intent. So they're not just going to work with one exclusive agent. They're going to have 10, 20, even more agents feeding them opportunities. And we have to know, but that's where this disclaimer of Section D comes into play. I'm excluding these individual properties from this agreement. And that's alleviates them from paying a commission. Next section is a lot of the forms say, all of commissions is, all of the commissions are not fixed by law, it's all negotiable, okay? So in theory is the reason we have this is because it's negotiated between the buyer and the agent. Okay, you may throw a number such as a 3%, right? But the buyer may say, I don't want to be responsible to pay you 3% of the sales price. Because think about it. If you make an offer on $1 million at 3%, how much is that? 30,000, right? That's 30,000 that the buyer has to pay you to find, identify, negotiate, close the deal. Is they're going to write a check for 30,000 on top of paying, their down payment, their closing costs, or paying cash for it. They would have to come with the additional funds to pay you if this is the direction you have to go, right? This is the direction you got to go. Okay. Let's see. I thought I saw someone come in. All right, so we're good here. Okay. So all commissions are negotiable. Section E1. Okay, let's go here. Amount of compensation, all right, 3% of the acquisition price, if any, okay? So that's where you're gonna put the amount of compensation. Now, that's what you wanna charge the buyer, okay? That's the amount that you wanna charge. It's up to you. The average is 2.5 to 3%, okay? Depending on the circumstances, I've seen in excess of 3% as well. It's standard. It's really not standard, but it's been standard in the industry since I've been in this industry, and I've been in the industry for quite some time. But it's whatever you want to charge, right? Because at the end, the buyer's responsible to pay. E2 goes into payment received by broker from seller or others, okay? And the beautiful thing about all of these new forms, it also has a section, if you want to get a little bit more understanding of what this means, you just go to 4G as an example, and it's going to give you the information. And it says the following: if a broker receives compensation from a seller or others for broker's representation of buyer, the amount shall be credited against the buyer's obligation to pay the broker. Here's the disclaimer, ladies and gentlemen, that says to, and how you explain that to the buyer is, look, we're going to go after the seller to pay me. So it says on paragraph E2, okay, that if I can get the seller to pay me compensation, then that offsets you responsible to pay me. Well, what if the question is, well, Simon, what if we submit a 3%, but the seller comes back and only offers us 2%? Okay. Then what? How do you explain that to the seller or to the buyer? That's a good question. There's a couple of things that we can do, 3 things. Okay. 1, if the seller is only going to pay me 2, right? And I have it here as 3, that means that you would be responsible, buyer, to pay me the difference. So the seller will pay me 2 and you would pay me 1. That's a discount right there. And you can smile at the buyer, right? That's 1. Number two, you can renegotiate that and send a counter that we're not wanting 2%, but I'll do 2.5%. Okay? And send a counter to the listing agent saying commission shall be, or compensation shall be 2.5%. Okay? Well, that's still a difference, right? That's still a difference between 3% and 2.5%. The buyer would be responsible, right? The buyer would be responsible to pay you 0.5% still. Okay, so, and number three is to the buyer says, look, if they only offer me 2% and we have a 3% agreement, I will offset that amount and squash it. Meaning I will have a new modification of buyer representation agreement modified to accept the 2% instead of the 3%. So you're not going to pay me the 1%. I'll take the 2% if that's the case. And all you have to do is just modify this agreement to reflect the lower amount that the seller is offering you. Does that make sense? Okay. Very simple. You can work with the buyer, right? Because you may be okay with 2%. We're just trying to throw it in the wall and I hope it sticks at 3%. But if they don't come back at 3% and they come back at 2, 2.25, 2.5, 3.75, then we need to know how to adjust the modification. You either accept it, you counter it, right? Or you have the buyer pay the difference. And some buyers may be okay. You might have found a good property at a good price, and they're very appreciative of that. And they'll say, look, I have no problem. I'm getting a good deal. So you're entitled to your 3%. You earned it. And there's buyers that are willing to pay you that. So that could be the beautiful thing is there is no gap. The seller will pay you and the buyer will pay you. And that will come through escrow, seller's concessions, and then the buyer will come in with the difference in closing fees and down payment. Does that make sense? Questions? Okay. All right, next is
Simon, I'm just curious about E1, the amount of compensation. When they say see attached broker created compensation schedule, does that mean we're kind of putting them on like an installment plan? Is this what I'm understanding?
Yeah. All right, that's a really good question. He's referring to this section here. See attached broker created compensation schedule. This is more commercial that I see this happening, not necessarily the residential realm, but in commercial, there's different tiers. Different tiers. Okay. The higher the amount, the lower amount of compensation. The lower amount, the higher compensation. So they'll start off with something like this. Any properties that we buy up to $1 million would be 3%. Any properties between 1 million and 5 million, right, would be 2.75%. Anything in excess of 5 million to 10 million, right, would be 2.5%. Anything over $10 million that you as a buyer buy the property, it'll be 2%. Does that make sense? So those are what can be tier created compensation schedules, right? Where if it's that, it also references to schedule, right? Meaning that you can put a specific time frame as well. If you find a property within the next 30 days, even though we have a 90-day agreement, but if you identify a property that I like within 30 days, I can give you an incentive or a bonus on top of the 3%, saying that I'm willing to pay you a bonus of 0.5% if we find a property within 30 days. Because it may be a situation of a 1031 exchange, right? 1031 exchange is you're selling an investment with a likelihood to find a property of equal or greater value. And they're pressed for time. You may just be that individual that says, look, I might have that specific property you're looking for. It's a positive cash flow. It makes sense. It's right price and it meets the expectations. but we need to get this done. And you work your tail off with the seller and the listing agent to get this deal done within that 30-day period or less. And because of that, the buyer may say, look, you found me a property, I didn't have to pay penalties on taxes. I'm okay giving you an incentive. You can put that as part of your compensation schedule. Does that make sense? Okay, I hope that kind of answers your question.
Thank
All
you.
right. The next one is continuing right to payment for broker involved properties. Okay, so this is a continuous period. You want to put a time there. I've always put 120, okay? And 120 is 4 months after, okay? After the expiration or cancellation of this agreement. Meaning that you can put anything you want, okay? It's left blank for that purpose. I've seen 30 days, I've seen 60 days, I've seen 90 days, I've seen 6 months. Whatever amount that is here in the seller initials and sign, that's what they're obligated. So what does this provision mean? Calendar days after the representation period or any extension continuous period. Because let's just say, for example, you have the BRBC sign and you don't find anything in the next 90 days, right? 3 months, because the agreement is for 3 months, right? But they still want to work with you, right? And now you do an extension of that BRBC. Okay, that extension for another 90 days. Okay, and then after maybe the 5th month, you find a property, right? But the deal falls apart and it doesn't go through. Now, remember, the original BRBC was 90 days, right? 3 months. And then you did an extension, right? An extension to this agreement for another 3 months. And then 2 months in, 5 months in, you find a property, you go into escrow, but it falls out of escrow. Buyer is discouraged, decides, I don't want to buy it. You know, we were in it for 5 months. It took us 5 months to find something. The deal didn't go through. I just want some time. Okay, not a problem. This 120 starts from that extension, not from the original, but anything from the original to any extension of the BRBC. Once you expire or cancel this agreement, that's when the time starts. So let's say that you and I agree to terms, but then we decide to cancel our agreement, okay? Because we can mutually agree to cancel. So today we cancel, today would be considered 0 days. Tomorrow will start to 120 period, 4 months from tomorrow. Okay, and if this buyer within that 4 months comes and buys a property that was broker involved, meaning you had some involvement with it, that one that fell out of escrow as an example, and then they go back to the buyer and say to the buyer, hey, I know we canceled, but I wanted to bring it to your attention. You may be interested in this property again. We reduced it, and the buyer says, yeah, I'd love to make an offer. But doesn't bring you because their mind thinks that they cancel with you, and that agent somehow on their registry, right? Because when you do open houses, what are agents doing? They're asking for name, numbers, and emails, right? And they look through it. Oh, I remember this individual. They ended up making an offer, and they call this individual, right? Because they have that right to do so, right? Calls and says, yeah, by the way, I submitted an offer. Oh, I remember you were that individual that made an offer. Are you still working with that agent? No, we decided to cancel that agreement. Okay, what should that listing agent do first and foremost? The one that reached out to your buyer. What do you think they should be doing? If the buyer says that we cancel, are they going to take the buyer's face value that the cancellation is done?
And she called the agent to confirm.
I would say, yeah, I would say get a copy. Say, do you have a copy of your BRBC? I do. All right, can you send it over to me? Okay. Send me any and all, any representation agreement, any extensions that you have. Send it to me so I can know if you're obligated to pay your previous agent compensation. And if it does say 4 months after the extension, then the the listing agents just say, look, based on this, you may want to reach out to your agent and let them know that you may be responsible, because if that agent finds out that you bought this property, did this individual agent provide you with a list of individual properties? Yeah, he did send me all of the properties that we looked at and also submitted this one. So yeah, as a listing agent, I would say, to protect you from paying, a commission, or commissions, you may be in a position to reach out and let them know, right? Because once the agent finds out and they have a valid agreement, yeah, we can go after compensation. Yes, sir.
And how do you find out you were the buyer's agent?
That's a good question. How do you find out if the buyer bought the property? Yeah, it's gonna be very difficult, right? Very difficult. The only way is you'll get a sense in your stomach, right? Sometimes these individual buyers, they're shady, very shady, right? And you'll get that feel, right? You'll know if something doesn't feel right, right? So what you want to do is monitor the listing. So you'll check that MLS, right? And consistently just kind of monitor. And if that property eventually becomes pending, right? And ultimately becomes closed, right? Then you'll know. And then when it becomes registered through the county recorders, you're going to see the name of that buyer, right? And with that, then you have recourses. Now, the question I get here is, well, the deal already closed. Don't you want to be able to do it before it closes so you can at least entrap the transaction? But again, how are you going to find out? How do you know if it's the buyer? Because the listing agent is not going to say, oh, it's John Smith that's buying, because that's confidential information. So it's not something that you're going to be able to know, only if you find a way that you know it is, right? But it's going to be far and few that you do. Yes, sir.
So I think number 83 is good for both a listing agent and buyer's agent, if they have to verify that we need to ask them.
Absolutely. Yeah, because you don't want to hold up a transaction because there's a dispute between compensation from a previous agent. Absolutely.
What is the time and what's the statute of limitation?
Well, it goes back to the statute of limitation is based on what you put here. So if it's within that time frame after this, right, then you don't have recourse for compensation. And then that buyer is free to go with whoever they want to. But during that time frame, right, that's why it's important that it gives you that extra layer of protection from a 90 days, right, BRBC to another 4 months, because you put that, but that's only if it gets canceled or it expires, and you provide a list to the buyer, to the buyer, that these are all of the properties that I've shown you, submitted offers, got an offer accepted, open escrow, but it canceled, and you provide that, and that buyer goes back and buys any of these properties, then you have the right to compensation. Okay, good question. All right, cancellation rights and notice, right? So non-exclusive cancellation effected upon receipt. Okay, so meaning that if you and I decide to cancel today, then it's canceled today. That's it, on a non-exclusive. You can also put days after receipt. Okay, it allows you to put that. But an exclusive agreement, the cancellation effects is 30 days, not to exceed 30 days after receipt. So what this means is it gives you that extra protection that on top of your 4 months, if you have an exclusive agreement, it allows you an additional 30 days. So 30 days plus 120, that's 5 months. I'll explain how that works. If you have if you have an exclusive agreement and you and the buyer decide to cancel, right, the agreement, because it's based on a cancellation right, 30 days, that within those 30 days, if that buyer goes back and buys a property that you were involved, broker involvement, right, then you're entitled to compensation. Then, what happened here? All right, stop. Let me see. Let me go back. It could be that it was my one second. I don't know why it does that now with zip forms. Bear with me, folks, on Zoom. Let me go back. Yeah, it timed out for some reason. But what it does, it allows you. It allows you to now have an additional time of that cancellation. Okay. So bear with me, people on Zoom. I'm getting my contract back up here. I should have done the desktop version. Okay, so go
Yeah,
back.
Simon, if you're not actually putting something on the contract, it'll knock you out of it. So you
Okay,
have to be like checking something or typing on it
got it,
in order for it to stay on.
got it. All right, so people on Zoom, do you see the screen or it's
Not
blank?
yet. We can
Yes,
see the
it's
screen.
on.
Yes.
I see it.
You see it now?
Yes.
Okay,
Well, yeah.
Just a video of it, Simon, not the actual form.
at the
So-
form.
No,
Okay, sorry about that. Let me see here. 1 second, please. Do you see it now?
No.
it just says has started screen sharing. Double click to enter full screen. Now we got
Yes,
it.
now. Yeah.
There it goes.
Okay, awesome, thank you. All right, let's go back to this section real quick. All right, so the cancellation is as that, right? So with an exclusive cancellation, it gives you 30 days on top of whatever amount you put up here too. So 120 days. So theoretically speaking, you have 5 months. If this buyer comes back and buys, then you're entitled to compensation, okay? G1 and G2 goes into time to deliver buyer personal financial information within 5 calendar days from the execution of this agreement, right? Then you can check the BFPI attachment, right? And we'll go into the sections right now on 9B and 1 and 9B2. Buyer does not have sufficient funds to pay broker. All right, so broker obligation to represent buyer in any transaction is contingent upon a seller agreeing to pay the amount of compensation. So let's just say that the buyer doesn't have sufficient funds, right? They're barely scraping enough money, right, to pay their down payment and closing costs, right? That can happen. So you're going to check here as part of the transparency that the buyer does not have sufficient funds. Now, let me be very clear on this, okay? This is why consulting, sitting down with the buyers and looking at their financials will determine, okay? Because there's 2 elements to this. Buyers have the money to pay you, or buyers don't want to pay you, okay? So you got to get that in perspective. So the conversation I would have with someone is, can I get a volunteer? Salvador, come up here real quick.
Yes.
Okay, give Salvador a round of applause. Let's say that Salvador is a buyer. But part of the initial conversation that I'm having with Salvador is, thank you for meeting with me. Part of the initial process to buy, and let's say that he has barely enough money, right? Because we're going to go with an FHA, which is 3.5%. We may need assistance with closing costs, right? So I know that he does not have the means to pay me 3.5%, right? I know that because part of the segue is I'm going to be in communication with the lender. If he tells me, or the lender says, well, how much proof of funds does he have? Well, he barely has enough to make this work. We looked at all his bank statements. We may need to ask for $10,000 of seller's concessions to help to be able to qualify. Otherwise, we're not going to be able to make a deal. Okay, then that's where I'm going to check G2, say the buyer does not have sufficient funds to pay the broker, even though the broker is responsible, right? But let's say that it's the total opposite, and Salvador has $500,000 cash in his bank account, right? he doesn't want to buy anything huge, but he wants to buy something, right? And he does have the ability to pay you compensation. So the question in the agreement is, let's say Salvador says, I don't want to pay you, Simon. Okay, so tell me that question.
Okay. I don't have sufficient funds to pay you.
Well, your bank statement says that you do have some.
Okay, I don't want to pay you that commission.
Okay, so that may be the question, right? He may not want to pay me, right? And that may be a legitimate question. It says, okay, well, and I get that you don't want to pay me. Couple options we're gonna do, right? We're gonna try to submit an offer that the seller pay me, right? And then the seller would be, if the seller does pay me, then it offsets you from paying me. But in these instances, if the seller does not pay me, right, or only pays me a certain amount, are you willing to pay me the difference?
Yes.
Okay, there you go. So at least I had that conversation. So I'm not going to check this box because it's not true, right? He has sufficient money, but it's the way you articulate the conversation. Is like, hey, I'm going to try my very best, Salvador, to ask the seller to pay me, right? But in those instances where I submit a 3% and they only offer 2.5%, are you okay paying me a difference of 0.5%?
Depends on the difference.
Yeah, it depends on the difference. Absolutely. And we can have that conversation at that time, but I don't have to. Because he can also say to me, Simon, look, as much as I like your professionalism, I don't want to pay anything. I know I have the means, but I don't want to pay. Okay. So I understand that. If that's the case and the seller is not willing to pay me, are you okay to either one, represent yourself if you want this property, or I'm out because I'm not going to work for free, Salvador. I'm just being honest with you. Or two, you're okay to walk away from that property and we go find another property that the seller is willing to pay you.
I'm willing to walk away so you can get some
Okay.
information.
Beautiful. Thank you. All right, let's give them a round of applause. Absolutely, right? And again, it's how you would present your case. How you present your case. Section 8 goes into additional terms, right? If there's any specific terms that you need to know and understand, then obviously you can put it, right? And there's not really that many additional terms, but it may be very specific. That's where you want to put that information.
So,
Yeah.
if it's flat no, then you give them 3 choices, 3 options. Like,
Yeah.
I don't wanna pay, but you say that you have option either represent yourself to.
Yeah, so if the buyer doesn't want to pay you, okay, then you're not gonna check this only if they don't have sufficient funds to pay you. Okay, this is why you need to ask the question and look at their financials, right? Because even though this says buyer does not have sufficient funds, but they really do, you're not gonna check that because that's not the truth. But the way you counter that objection is, look, Mr. Buyer, I understand that you don't want to pay me. Okay, that's not the point here. The point is, if there is a difference where you just don't have the means to pay me, then I get it. You're going a 3.5% FHA loan, right? And you're barely scraping enough money. And after talking to the lender says we're still short by $10,000. How in the heck is he going to pay you 3% of the purchase price plus the 10,000? It's not going to happen, right? So in those instances, then you are going to check that section.
So when you check that section, that box, it means that you're gonna get compensated other ways, or you just don't get compensated.
By checking this,
Yes.
yeah, if you check this, is what you're stating, and the buyer saying is that they don't have the means to pay you commission, because the agreement says that the buyer is responsible to pay you compensation. But remember, it also said earlier that if anyone else than the buyer pays you, then it credits the buyer's obligation to pay you compensation. This is only if the buyer does not have the means, okay? They may have the means, but they may say, I don't want to pay you regardless. I have the money to pay you, but I don't want to pay you. And that's okay. That's perfectly fine, okay? Then you can say the 3 things. Look, one, if the seller doesn't pay me, you're not willing to pay me, then I have to walk away from this agreement. I'm not gonna work for free. I need someone to pay me. Okay, if I'm gonna do all of the negotiations and get you from point A to point B, I gotta get paid. And if the seller is not gonna pay me, then I'm gonna ask you to pay me. And if you're not willing to pay me, I get it and I respect your decision. Then I need to walk away from this agreement. You have one option to work with the listing agent directly as a non-represented client, or you walk away from this deal and we go find another property that the seller is willing to pay compensation.
Simon,
Okay.
a question.
Yes.
When Salvador say, I will pay you, yes, if the buyer didn't pay you. So is there any way we can put this in paper to protect us if the seller say, the seller say, no, I'm not going to pay you. And then Salvador, he said, yes, I will pay you 1% if the seller didn't pay you. We can put this in somewhere in paper or just like the mouse of word?
Yeah. That's a good point. The question here is, if Salvador, as an example, says, and now it makes sense to him, and he has the means to pay you compensation, right? And then Salvador says, look, after we explore all resources and the seller still says no to paying you a compensation, I'm willing to either pay or pay the difference. Okay, because let's say that the seller comes back at 2%, right? And you put 3%. The buyer, Salvador, in this case, would pay you that 1%. Okay. So this is where you can put it on other terms, where you can put that if the seller pays you less than what's agreed upon, the buyer would be responsible to pay you the difference, and you can put that in writing. So now the buyer, Salvador, and me as the buyer's agent are clear that it says that if any differences, he would consider to pay me the difference. And you can put that in writing on other terms. Okay, and that's still negotiable, because let's just say that it's 2% that the seller pays you, 1% that the buyer is responsible on the difference. And then it comes back, Salvador maybe said, well, Simon, 1% is a big chunk. Can we negotiate that? I'll pay you 0.5%. Well, we have it in writing that's 3%, but I want to make this deal happen. Why would I not work with Salvador, right? I'm looking at future business. I'm looking at referrals from him. He's eventually going to be a seller. And if I do good with him, in return, he's going to do good for me. So I would say, not a problem. I'm willing to get 0.5% from you. I'm good with that. Make sense? Yes, sir.
They also offer a fixed dollar amount, say, hey, I cannot pay you X dollar amount, but you know what? I can only gather $8,000.
Yeah, it can also be a flat fee, 100%. It doesn't have to be 3%. It could be a flat fee too. But keep this in mind, folks, okay? Because I get this quite often. We're not a discount brokerage, okay? We're not a discount brokerage, right? Someone has to pay you for services rendered, because your minimum deductible on an errors and omissions claim is $15,000 minimum. And that's a percentage that you as an agent and the company pays. God forbid that ever happens, right? Where we have to get E&O insurance because of damages, and now that someone has to write a check, but you have that layer of protection. But you don't want to do anything less than that, because if you go into litigations and now we're writing a $60,000, $100,000 check, there's a deductible that you're paying. And if you discounted your agreement because that's who you are, keep in mind, this can come back to haunt you too, folks. Okay, no difference in automobile insurance, right? You never want to be in an accident, but you have that insurance in place that if you do damage your vehicle or someone else's vehicle, that they're going to be taken care of. That's kind of the same thing with our E&O insurance. All right, let's continue, guys. All right, advisories. The rest of the stuff is basically advisories, addendums, and disclosure. Remember, compensation is negotiable, never fixed. It's between the buyer and the broker. All of the information, and I urge you, okay? I urge you to read all this, because it gives you all of your answers to all of your questions if you thoroughly just read it. And read it once and read it again every once in a while, because again, if you have a very analytical buyer, such as an engineer, right? The engineer is gonna dissect this and it's gonna ask you some tough questions. What if this? What if that? What if this happens? What? And if you don't have an answer because you're not reading the contract, not that you're practicing law, right? But you have to understand the basics to get you through that, right? Because why would I sign an agreement if the agent doesn't even know? Okay,
So I mean, I had a case.
I would be very, very careful with that. Yes.
I had the exact same case this week where the buyer asked me, "Can you show me where on the BRBC it says that I will only pay you money if we close the deal?" And it's all because I had some ideas, but it's just, I think it's just below this, like that it's down there, that it says the time of compensation. There you go. That I was able to point it out, and then you know what? Okay, I'll just sign it then.
Yeah, beautiful. Section D, time of compensation. So here's the section that says the continuance to compensate, right? And it goes into broker involvement, right? Time of such payment is subject to whatever you put in paragraph D, and the right of compensation pursuant to the paragraph that only apply prior to the expiration, right? Broker delivers buyer a written notice of those properties for which there was broker involved. There's your answer. The section he's talking about timing of compensation is payable, and it has 1, 2, and 3, right? Upon completion of any resulting transactions through escrow. So if it doesn't, if it's not completed, they're not entitled to pay you. It has to be on a successful completion resulting through a real estate escrow company closes officially, then yeah, you should be obligated to get paid. Broker shall be entitled to compensation whether any escrow resulting from this agreement closes during your period time, your representation period. If the acquisition is prevented by default of the buyer upon buyer's default, if that's another way of recurring your compensation. If the buyer makes it very difficult and we have the evidence and proof that the buyer's making it difficult, then because let's say they're wasting your time, right? And for the people that need to leave, I know we're past our time. I respect that, not a problem, but if you want to stay here, I'm almost done, please stay. But for the buyers that are just wasting your time, they're making offers canceling, they're just not taking it serious. And I've seen buyers that way. You know, they start lowballing, right? Lowballing offers, and then they get their offer accepted. Well, you know, but wait a minute, we just made an offer lower than, and you got it accepted, and now you want because you're not liking it. Then we can argue that fact. Says, look, in front of a mediator or an arbitration case, this is the reason I feel that I'm entitled to my compensation because the buyer made it very difficult. On section D of the BRBC, under D2, it says preventing by default of the buyer because of the buyer's default. Okay. Now you can twist it, you can turn it the way you want. This is why you want to document everything, folks. Because now you can have the evidence and the proof, right? That says, right? This is exactly what happened and why the buyer has made it very difficult for me to get paid. I did everything in my capacity to make this work. It's not my fault. I still need to get paid. I feel like I wasted all my time and energy on someone that is not taking me serious. Then you can go after compensation. Preventing the party from the transaction other than the buyer when the buyer collects damages. Okay, so if there's a breach, right, the buyer goes into escrow and now the seller ultimately makes it very difficult and there's a litigation on it and the buyer wins compensation, which is far and few, but if they do, then we're also able to collect some of that money too as well. Very far and few that happens, but it's here as well. Okay. Payment through escrow, pretty self-explanatory. Is assigned to broker compensation provided by this agreement that all compensations are through escrow and only through escrow. Commissions should not be done directly, right? It needs to go through the brokerage. Only the brokerage has the authority to allow escrow to break the commission and pay you directly from escrow. But that has to be the authority and responsibility of the brokerage. Okay. All right. Sorry. Cancellation, we went through the cancellation. Possible, meaning that you may be responsible, you may be working with multiple buyers and they may be submitting offers at the same time with the same property. So it's just a disclosure. Multiple buyers, and it goes into all that. Broker's authorization and obligation, pretty self-explanatory. Read it, what it says when it comes to broker will assist buyer buy, and here's all of the stuff that obligates. Buyer's obligation, I like this section, which is 9A, good faith. Buyer agrees to timely view, consider property selected by broker, negotiate in good faith to inquire a property, and buyer further agrees to act in good faith towards completion of the contract entered in for the property. There it is, man, in good faith, and if the buyer's not in good faith, then we may argue the fact that we may be entitled to compensation. And then here's this section of financial and personal information, reasonable care and professional assistance. I'm not going to go into it, but read the contract, folks. Manager approval. So within 5 days, if we feel that this agreement is, this is why we have compliance. So if you submit this and it shows $500 as compensation, well, we may see this as a situation, right? But we'll look at the whole totality of it, because if you're getting compensation from the seller, then it's okay to put $500, because then that's what the buyer's responsible for. Okay, then it goes into the mediation, which is pretty self-explanatory, legal authorization, making sure that the right people have the legal capacity to sign and agree. The entire agreement is anything and everything regarding this BRBC and all of the advisories. That is your hook, and that is how you can ultimately get paid for services rendered. And then it talks about the exclusive representation under here, and it has the buyer initial, understanding that this is an exclusive agreement. If the buyer is an entity, as we said, an LLC, S Corp, C Corp, then, obviously we can extend that period for more than 90 days. But who is in the capacity, right? Who is the officer, the CEO, the vice president, the treasurer, the members, the partners, who is able to sign on behalf of this agreement? So this information goes there. Then you get the
with that regard in LLC, where do you explain the timing and how much more time can you put on there?
On the very beginning of the BRBC. So if you go back here, okay, and you see this section here, not to exceed 3 months unless it is a corporation, LLC, or a partnership as required under California Civic Code 167. If representing period exceeds that 3 months, buyer is not an entity, this agreement is void. So that's the section there where if this is a corporation, then the 3 months does not apply. You can then go 6 months or more with this entity. That's where you explain it.
Okay.
All right. Well, team, that concludes our class. I sincerely apologize for going 10 minutes over my time. Any other questions?
Thank you so much.
Thank you.
Okay.
Quick question. Hopefully.
Yes.
If the list that you're gonna give a buyer afterwards, if they say property, I give them a choice of A, B, and C. Let's go look at B. They wanted to see B and C, but they didn't choose A. When
you.
I give them their final list at the end, can I still include A just in case they come around or because I didn't really go show them the property, I just showed it to them on paper? Does it count or no?
Remember, when it comes to broker involvement, right? That's the key. Let me pull this up real quick. 1 second. Where it says broker involvement. All right, so what it says for broker involvement, what used in this agreement means any of the following. It says, buyer physically entered and was shown the property by the broker. Broker showed the property to buyer virtually. Broker submitted to seller a signed written offer from buyer to inquire, lease, exchange, or obtain an option on this property. Broker performed a market analysis related to the property or view the property specific documents or disclosures with the buyer. The property was introduced to the buyer by broker or one of which broker on buyer's behalf. However, merely sending buyer a list of properties shall not be deemed broker involvement. The document action on the part of the broker analyzing the property for buyer, specifically or assisting buyer in the potential acquisition of the property, or communicating with the seller or seller's agent regarding buyer's potential acquisition of the property. That's how you can articulate your position of broker involvement. So physically shown, a virtual of the property, submitted an offer, did some type of an analysis like a CMA or value check. Here's and we have proof of it, and that you can use as broker involvement. The property was introduced to the buyer because of you, even though someone else brought it to you and then you bring it to the buyer, that's still considered broker involvement. Okay?
Okay, thank you.
All right. Thanks, everyone. Appreciate your time. I'll see you in the next contract class. Have a good weekend, guys. Thank you.
Thanks. I may have a weekend.